Whether a sitting judge has the power to pronounce a judgment written but not pronounced by his predecessor judge. The question whether a successor or sitting judge can pronounce a judgment written but not pronounced by his predecessor depends upon the provisions of the relevant procedural law. The distinction between civil and criminal proceedings is important in this regard. Under Order 20, Rule 2 of the CPC, where a judge has written a judgment but is unable to pronounce it due to death, transfer, retirement, or any other reason, the successor judge is empowered to pronounce the judgment written by his predecessor. Therefore, in civil proceeding, a successor judge may pronounce a judgment that was prepared but not pronounced by the predecessor judge. However, the position under the Code of Criminal Procedure 1973 is different. Reference is often made to Section 326 of the Code of Criminal Procedure 1973, which permits a successor judge or magistrate to act upon evidence recorded by his predecessor and continue the trial from the stage at which it was left. Nevertheless, this provision does not expressly authorize a successor judge to pronounce a judgment already written by the predecessor judge after the predecessor judge has ceased to exercise jurisdiction over the case. Further, Section 353 of the Code of Criminal Procedure 1973 requires that every judgment in a criminal case must be pronounced in open court in the manner prescribed by law. A judgment becomes effective only when it is formally pronounced by the judge having jurisdiction over the case. It has therefore been argued that if a judge writes a judgment but does not pronounce it before ceasing to have jurisdiction, such judgment does not become a valid judgment in the eyes of law. Consequently, a successor judge cannot ordinarily pronounce a criminal judgment written by his predecessor unless there is a specific statutory provision permitting him to do so. Thus, while the CPC 1908 specifically authorizes a successor judge to pronounce a judgment written by his predecessor through Order 20 Rule 2 of CPC 1908. No similar provision exists under the Code of Criminal Procedure 1973. Therefore, the legal position in civil proceedings differs from that in criminal proceedings. Conclusion. Thus, a successor judge may pronounce a judgment written but not pronounced by his predecessor in civil cases under Order 20 Rule 2 of the CPC 1908. However, in criminal proceedings under the Code of Criminal Procedure 1973, there is no corresponding provision, and generally, a successor judge cannot pronounce a judgment written but not pronounced by his predecessor after the latter has ceased to exercise jurisdiction over the case.